Ghatna Chakra, Supreme Court questions. Okay, page number is D242. The first question is, when was the Supreme Court inaugurated in India? So the date is just 2 days after the Constitution came into force. Constitution came into force on 26th January 1950, and the Supreme Court was inaugurated just after 2 days of it. So it will be on, and it has been on 28 January 1950. Okay, just 2 days after the constitution came into force. So the next question is, the sanction strength of Supreme Court of India is. The Supreme Court of India was established according to Part 5, Chapter 4, Article 124 of the Constitution of India, and is the highest judicial forum and the final court of appeal. Okay. Establish of the Supreme Court of India, its composition and jurisdiction has been laid down in Article 124 to 147 of the Indian Constitution. Initially, during the 1950s, the Supreme Court consisted of Chief Justice and 7 judges. Now, currently, it is 34 judges in total. So if we will talk about it, then 33 judges and one chief justice, in total 34 at present. Okay, during the 1950s early time, the Supreme Court consisted of a chief justice and 7 judges, in total 8. Okay, in 1956 the number rose to 11, and it kept rising to 14, 18, 26, and 31, including the chief justice, in the following years. It is noteworthy that the Supreme Court Amendment Act 2019 has increased the number of judges in Supreme Court from 31 to 34. Currently, there are total 34 judges in the Supreme Court, including Chief Justice. Okay, and one more thing, the increment or the thing has is done by the Parliament, like how many judges will be there, and the increasing number of judges has been decided by the Parliament, or is to be decided by the Parliament. So, okay, the next question is, the Supreme Court consists of a Chief Justice, and so it depends, like on the year it depends, like uh, this is the question of 2007. Okay, so at that time there were 25 judges. At present, after the 2019, uh what was the name of that, uh Supreme Court Amendment Act of 2019. Okay, after that the number of judges has been increased to 34. So at present there are 34 total judges, including the Chief Justice of India. So the next question is, the fourth question is also the same. The current sanctioned strength of judges of Supreme Court of India, it is 34, including the Chief Justice of India. Next question is, according to decision taken by the cabinet in Feb 2008, the government would increase the strength of judges in the Supreme Court under this decision, apart from again the same question. It is not valid now. Okay, the next question is, Supreme Court in India was established by, so then it is established by the Indian Constitution. Okay. The Supreme Court of India was inaugurated on 28th January 1950. It succeeded the Federal Court of India, established under the Government of India Act 1935. So it is important that which court did it succeeded. Okay, so it is Federal Court of India. Okay, it succeeded the Federal Court of India, established under the Government of India Act 1935. Okay, which court Supreme Court has succeeded? So it is Federal Court of India, which was established by the Government of India Act 1935. Okay, the next one is, of the following statement, which one is not correct? Supreme Court was constituted in 1950. This one is correct. Supreme Court is the highest court of appeal in the country. Okay, this is also in our country it is. Okay, this is correct. The next one is, Supreme Court can hear from any high court tribunal except court martial. Supreme Court can hear from any high court tribunal except court martial. Okay, the next one is Supreme Court can hear from any high court tribunal as well as from the court martial. So the last one is wrong. Okay, but I don't know why the answer is C. D would be the correct answer. Supreme Court cannot hear from the court martial. Okay. Armed Force Tribunal Act 2007 provides that the court martial can be applied in the Supreme Court. Okay, appeal. Okay, okay. It is about appeal, na? But still, Supreme Court can hear from any high court. I need to verify this one. Wait. The next question is the power to increase the number of judges in the Supreme Court of India is vested in. So it is vested in the Parliament. Okay. The Parliament will look after how many judges should be there. The recent one has been passed in 2019 and it increased the number of judges to 34. Okay. Article 124 of the Constitution provides for the formation of the Supreme Court. The power to increase the number of judges in the Supreme Court of India is vested in the Parliament. The next question is a judge of the Supreme Court may resign his office by writing a letter to the president. Okay. According to Article 124 to clause 2A of the Indian Constitution, a judge may by writing under his hand address to the president resign his office. Every judge of the Supreme Court shall be appointed by the president by warrant under his hand and seal and shall hold office until he attains the age of 65 years. And for high court it is 63 years. Okay. And the article which talks about Supreme Court formation is 124. Formation is the correct word or not? Okay, 124 formation, yeah, correct word. Okay. So the next one is who appoint the judges of the Supreme Court of India. The judges of the Supreme Court of India are appointed by the president, but after the consultation, and the word consultation is binding here, after the consultation from the uh, collegium, okay, of which is made up of Chief Justice of India, which is made up of Chief Justice of India, uh, some expert jurist and other high court judges. Okay. The next one is what is the retirement age of the judges of the Supreme Court? It is 65 years of age. A judge of Supreme Court may resign his office by writing to the president. How can a judge of the Supreme Court be removed? It can be removed by the president on the recommendation of the parliament. Okay. According to Article 124, Clause 4, a judge of the Supreme Court cannot be removed from his office except by an order of the President passed an address in each house, and the basis will be misbehavior and incapability. Parliament supported by a majority of total membership of that house and by a majority of not less than two-thirds of the members present in voting and presented to the president in the same session for such removal on the ground of proved misbehavior or incapability. A person who has been a judge of the Supreme Court is debarred from practicing in any court of law or before any other authority in India. Impeachment word is used only to remove the president. The term impeachment is not used to remove the judge of Supreme Court or High Court. The word remove has been used in the Constitution to remove them. Okay, so the removal of the judge is being used, the word is being used or removal, whereas when we remove a president the word changes to impeachment. Okay. The next one is a judge of the Supreme Court can be removed by the president of India after an impeachment by the parliament, but just the above thing said that the word impeachment should not be there, but still it is. Okay. So the next one is consider the following statement. The motion to impeach a judge of the Supreme Court of India cannot be rejected by the Speaker of the Lok Sabha as per the Judges Act 1968. Okay. it can be rejected now, but of 1968, I don't know. The Constitution of India defines and gives details of what constitute incapacity and proved misbehavior of the judges of the Supreme Court. Okay, no, it is not clearly defined. The next one is the details of the process of impeachment of the judges of the Supreme Court of India are given in the Judges Inquiry Act 1968. I don't have any clue about it. If the motion for the impeachment of a judge is taken up for voting, the law requires the motion to be backed by each house of the parliament and supported by a majority of total membership of the house and not by less than two-thirds of the voting. Okay, yes. So the answer is 3 and 4 only. Okay. Hmm. First one is not working now, but it was also not working at that time in 1968. And the second thing that the definition of incapacity and proved misbehavior is not been defined. So these two are wrong. Whereas the third one, that the details of the process of impeachment of the judges of the Supreme Court of India are given in the, this one is correct. It is given in the Judges Inquiry Act 1968. Okay. The next one is also correct. The motion to remove a judge of the Supreme Court of India can be rejected by the Speaker of the Lok Sabha as per the Judges Inquiry Act 1968. So this one is wrong, the first statement. The second is the details of the process of removal of judges of the Supreme Court of India are given in the Judges Inquiry Act 1968. Okay. Okay, the details of the process of removal is given in where? So it is given in the Judges Inquiry Act 1968. It is important. Article 124. 4, 124 4. A judge of the Supreme Court shall not be removed from his office except by an order of the President passed after an address by each House of the Parliament supported by a majority of total membership of that House and by a majority of not less than two-thirds of the member of the House present and voting has been presented to the President in the same session for such removal on the ground of proved misbehavior or incapacity. Thus, the Constitution provides the ground for removal for judges of the Supreme Court, but it does not proved misbehavior or incapacity. Okay. So the details is being given in the Judges Inquiry Act 1968. The next one is the age of retirement is 65 years, whereas of High Court is 62 years, 3 years earlier. The age of a judge of the Supreme Court of India shall be determined by such authority and in such manner as Parliament may by law provide inserted by. So it was inserted by the 15th Constitutional Amendment. Okay, the 15th Constitutional Amendment Act 1963 says the age of judge of the Supreme Court of India shall be determined by such authority and in such manner as Parliament may by law provide. 16th Constitutional Amendment Act 1963, herein after the bill was informally referred to as the Anti Succession Bill. It was designed to prevent the local political leaders in different regions within India from using the electoral process to peacefully propagate secession from the Union. The 17th Constitutional Amendment Act of 1964 deals with the amendment to Article 31A. The 18th Constitutional Amendment Act of 1966 amended Article 3 of the Constitution in order to clarify the state in clause A to E of that article. So the age, in short, the age of the Supreme Court judges has been inserted by the 15th Constitutional Amendment Act. So the 15th Constitutional Amendment Act decided the decided that the Parliament will decide the age of the judges. Salaries of the judges of Supreme Court are determined by the Parliament, obviously. According to the Article 125 1 of the Constitution, there shall be paid to the judges of Supreme Court such salaries may be determined by Parliament by law until provision in that. Yeah, okay. So these are the things. And okay. अगर किसी रिटायर्ड जज को वापस से बुलाना है, एज अ जज वापस से रखना है, मतलब ये फॉर अ लिमिटेड पीरियड ऑफ टाइम एंड द मैक्सिमम टाइम में exceed to 2 years. The next question is, what is the provision to safeguard the autonomy of the Supreme Court of India? First one is, while appointing the judges of the Supreme Court, the President of India has to consult the Chief Justice of India. While appointing the judges of the Supreme Court, the President of India has to consult. This is correct. The second one, the judges of the Supreme Court can be removed by the Chief Justice of India only. No, by the President. The salaries of the judges are charged on the Consolidated Fund of India, to which the legislature does not have to vote. This is correct. The next one is, all appointment of officers and staffs of the Supreme Court of India are made by the government only. After consulting the Chief Justice of India, all appointment of officer and staff of the Supreme Court of India are made by the government only. It is not made by the government, it is made by them only. So, first is correct. The judges of the Supreme can be removed by the Chief Justice only. Second is wrong. Third is correct. Fourth is correct. No, fourth is also wrong. So, which one are correct? Two are correct. Now, which one? One is correct, and then three is correct. Okay. So, the Supreme Court is considered as the guardian of the Constitution. The judges of the Supreme Court can be removed by order of the President, which must be supported by a majority of each House of the Parliament and not by the Chief Justice of India. While appointing the Supreme Court judges, the President of India has to consult the Chief Justice of India to safeguard the autonomy of the Supreme Court. Okay, the salaries of the judges are charged on the Consolidated Fund of India. Hence, statement 1 and 3 are correct. The Chief Justice of India can appoint officers and servants of the Supreme Court without any interference of the executive. He can also prescribe their condition of service. Okay. Okay, I missed the page. Wait. Okay, wait. Okay, we did this one. We did this one. Okay. The judges of the Supreme Court after retirement are permitted to carry on practice before they are not permitted. Okay, so the D is the correct answer. According to Article 124(7) of the Constitution, no person who has held office as judge of the Supreme Court shall plead or act in any court or before any authority within the territory of India, while Article 220 of the Constitution provisions that no person who after the commencement of this Constitution has held office as a permanent judge of a high court shall plead or act in any court or before any authority in India except the Supreme Court and the other high courts. So Article 124 7 deals that they won't work after the retirement. Okay, the next one is, acting Chief Justice of the Supreme Court of India is made by the President itself. The acting Chief Justice will be made by the President. Also, the Chief Justice will be appointed by the President itself. But talking about the other judges, like the ad hoc judges, acting judges, except other than the main Chief Justice, will be appointed or will be made by the Chief Justice of India, like the temporary ones. According to Article 126 of the Indian Constitution, the acting Chief Justice of the Supreme Court is appointed by the President of India. It is done if the post of Chief Justice is vacant or he is unable to discharge his duties. There is no provision of additional judge in Supreme Court of India. Okay, next one. There is no provision of additional judge in Supreme Court. Okay, they don't have extra judges. Okay. Which of the following type of judges can be appointed in the Supreme Court of India? Ad hoc judges can be appointed. Yes. So one is correct and two is false. Ad hoc judges are the extra temporary judges or the acting judges other than the Chief Justice of India. Acting Chief Justice of India is appointed by the President. Next one is with the reference to the Indian judiciary, consider the following statement. Any retired judge of the Supreme Court of India can be called back to sit and act as a Supreme Court judge by the Chief Justice of India with prior permission of the President of India. This is correct. A High Court in India has the power to review its own judgment as the Supreme Court does. Both are correct. Wait, what? Yes, both are correct. As per the Article 128, Chief Justice of India may at any time, with the previous consent of the President, request any person who has held the office of a judge of the Supreme Court or of the Federal Court, or who has held the office of a judge of a High Court, and is duly qualified for appointment as a judge of the Supreme Court, to sit and act as a judge of the Supreme Court. Article 215, High Court to be courts of record. Every high court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself. So both article 121 says that a retired judge of whether Supreme Court or High Court can be called again after the consent of the President and with that person. The next one is Article 215, which states that High Court or Supreme High Court can review its judgment again, and similarly Supreme Court can also do that. So both the Article 128 and 1 and 215 are important. Okay, the next one is the judges of the Supreme Court are appointed by the President on in the consultation with the Chief Justice of the Supreme Court. Okay, the last one. Yes, according to Article 124 Clause 2 of the Indian Constitution, every judge of the Supreme Court shall be appointed by the President after the consultation with such of the judges of the Supreme Court and of the High Court in the state as the President may deem necessary for the purpose. However, in case of appointment of a judge other than the Chief Justice of India, the Chief Justice of India shall always be consulted. Consultation with the Chief Justice of India was made obligatory by a decision made in 1993. Okay, so it is binding over the President to consult the Chief Justice of India. In 1998, the Supreme Court made it clear that the Chief Justice of India's consultation means the consultation of the collegium with which comprises of Chief Justice of India and four other senior judges. So the year 1998 made it binding to consult with the collegium. Okay. Okay. The next one is ad hoc judges are appointed in the Supreme Court when the judges are not there, not present. Some judges go on leave. No one is available for permanent appointment. There is an abnormal increase in cases pending before. C is wrong. There is no quorum of the judges available to the court. D is correct. Okay. A is same but not so correct. Some judges go on long leave. This is not correct. There is no quorum of the judges available to hold. This is correct. Under Article 127, one of the consultation, Article 127 is again important because it talk about the ad hoc and the and okay, acting Chief Justice one is also important. That article I need to check which one is that. Okay, so under Article 127 one of the Constitution, at any time if there should not be a quorum of the judges of the Supreme Court available to hold or continue any session of the court, the Chief Justice of India may, with the previous consent of the President and after consultation with the Chief Justice of the High Court concerned, request in writing the attendance at the sitting of the court as an ad hoc judge for such period as may be necessary of a judge of a high court duly qualified for appointment as a judge of the Supreme Court to be designated by the Chief Justice of India. Next one is the Indian Constitution provides for appointment of ad hoc judges in Supreme Court. Yeah. In In High Court, it is called acting judges. In which year was the collegium system for the appointment of judges adopted? It is 1993. Okay, yeah, 1993. But earlier one it was given 1998. In this one, 1998, the Supreme Court made it clear that the consultation means, and here it is 1993. What was it? Consultation with the Chief Justice was made obligatory by the decision made in 1993. Okay, it just talk in 1993. It just talked about the consultation with the Chief Justice, while in 1998 it talks about that the college. It talks about collegium. Wait, let me verify it from the book. The correct answer is 1998. Okay, and the earlier one, the seventh question, which was there, where it is, seventh one, huh? Okay. Supreme Court was constituted in 1950. It is correct. Okay. It was constituted on 28th January 1950. Okay. Supreme Court is the highest court of appeal. This is also correct. Supreme Court can hear from any high court tribunals except court martial. This is also correct. The next one, Supreme Court can hear from any high court tribunal as well as from the court martial. It is wrong. It cannot hear from the court martials. Okay. But they can appeal it. Okay. Yeah. But they can appeal to go through the thing. The next one is the Supreme Court's collegium comprises the Chief Justice of India and a few senior judges for recommending appoint to the Supreme Court. The number of such senior judges who are part of this body are. Supreme Court's collegium comprises the Chief Justice of India and few senior judges. Okay. I think four. Yeah, four is the correct answer. The Supreme Court's collegium comprises the Chief Justice of India and four senior judges for recommending appointed to the Supreme Court. The minimum number of judges of the Supreme Court required for hearing any case involving interpretation of the Constitution is five. Okay. The minimum number of judges of the Supreme Court required for hearing any case involving interpretation of the Constitution is five. Okay. There is minimum five judges of the Supreme Court required for hearing. It is designated as constitutional bench. Nice. Wait, let me write. Next one is the power of the Supreme Court of India to decide dispute between the center and the state falls under original jurisdiction. Article 131 of the Constitution of India deals with original jurisdiction of the Supreme Court. According to this article, Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute between the government of India and one or more state, or between the government of India and any state or states on one side and one or more states on the other side, or between two or more states if and in or so far as the dispute involves any question on which the existence or extent of a legal right depends, provided that the said jurisdiction shall not extend to a dispute arising out of any treaty, agreement, covenant, engagements, and or other similar instrument which, having been entered into or executed before the commencement of this constitution, continues in operation after such commencement, or which provides that the said jurisdiction shall not extend to such a dispute. Okay. So article 131 deals with the original jurisdiction. 131 original. Okay. 132 deals with the appellate jurisdiction. Maybe I'm not sure. Next one is which of the following are included? Wait, let me be sure then. So. Wait, let me check that. Yeah, the first one is original jurisdiction, 131, 132 writ jurisdiction. The next one is appellate jurisdiction, 133. Okay, and so on. Appellate jurisdiction is 132. Okay. Which of the following are included in the original jurisdiction of the Supreme Court? A dispute between the government of India and state or more state, one is correct. A dispute regarding election to either house of the parliament or that of legislature of a state. Okay, state one will fall under High Court. A dispute regarding elections of either house of the parliament or that of a legislature of a state. I'm not sure about two. Maybe or maybe not. A dispute between the government of India and a union territory. This is correct. A dispute between two or more states. Correct. I think all are correct, or maybe two and two. Let me check the answer. Answer is C. 1 and 4 are correct. 1 and 4 are correct. Only 1 is correct, 4 is correct. While 2 and 3 are wrong. A dispute between the government of India and a union territory. A dispute regarding election to either house. Okay, let's read the answer again. Between the government of India and one or more states. Okay, 1 is correct. Next one is between the government of India and any state or states on one side and one or more states on the other side. Means government of India and state. Mm-mm. Between two or more states, if and so far the dispute involves the question on which the existence. Okay. 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 If the question is not about law, I don't know. I need to check this one. Question number 32. Okay. Question number 33 is the second largest bench constituted by the Supreme Court till date was Golaknath case, Minerva Mill case, bank nationalization case, TMA Pi Foundation case. So it is Golaknath case. The largest bench, 13 judges constituted by the Supreme Court till date was in the case of Keshwan and Bharti case, 13 judges. Oh my god. The second largest bench was 11 judges constituted by the Supreme Court till date and was in the case of Golaknath versus the state of Punjab 1967. Okay, the next one is in which of the following cases the Supreme Court of India enunciated the doctrine of basic structure? So it was Keshwan and Bharti case, the most popular case of all time. In the case of Keshwanand Bharati versus State of Kerala, a 13 judges bench of the Indian Supreme Court by a majority of 7 is to 6 stated that the parliament could only amend the constitution to extent that it did not damage or destroy the basic structure of the constitution. Under Article 368, constitutional amendment are subject to judicial review. The court essentially plays a substantive non-legislative check upon the parliament's power of amendment. Which one of the following cases propounded the basic structure? So it is none of the above because it is Keshwanan Bharati case versus State of Kerala. Okay, the minimum number of Supreme Court judges who can hear a case involving it is 5. 5, 5, 5, yeah, 5. Okay. So there should be minimum 5 or more judges to hear a case involving a substantial question of law as to interpretation of the constitution. The panel generally contains judges in odd number, for example 3, 5, 7, 9, 11. This is done to avoid any clash of votes or views. Okay, so odd number. Okay. The next one, in which of the following cases Supreme Court held that fundamental rights enable a man to chalk out of his life in the manner he likes best? Okay. So it is Golaknath versus the state of Punjab. The Supreme Court held the above concept in the case of Golaknath versus the state of Punjab. Identify the incorrect pair of the case ruling in that case by Supreme Court. So So let's move to the answer. Bela Banerjee case is related to the West Bengal Land Development and Planning Act 1948. Right to travel abroad as a part of personal liberty was considered in the case of Menka Gandhi in 1978. The pair D is incorrect. Okay, rest all the case things are correct. Remember the incorrect pair. Indira Sawhney case, creamy layer for other backward classes. Vishakha case, protection of working women against sexual harassment at their place of work. Menga Gandhi case, Article 14, 1921 are mutually exclusive. Which article of the Constitution of India deals with the appellate jurisdiction? So it is 132. 131 deals with the original jurisdiction, 132 deals with the writ jurisdiction, and 133 deals with the appellate jurisdiction. So 132, 133. D is the correct answer. No, no, C is the correct answer. Article 132 read with Article 134A. Okay. Article 131 of the Constitution of India deals with the original jurisdiction of the Supreme Court. Article 132 deals with the appellate jurisdiction of the Supreme Court. In appeals from High Court in following cases, any judgment, decree, or final order of a High Court in the territory of India, whether. Okay, I need this page again. Okay. All the cases regarding the interpretation of the Constitution can be brought to the Supreme Court under its appellate jurisdiction. Yeah. All the cases regarding the interpretation of the Constitution can be brought to the Supreme Court under its appellate jurisdiction. The appellate jurisdiction of the Supreme Court can be divided into following heads. The appellate jurisdiction of the Supreme Court it in appeals with in appeals from High Court of any judgment, decree, or order passed by High Court in the territory of India, whether in civil, criminal, or another proceeding that involves a substantial question of law or interpretation of the Constitution. The appellate jurisdiction of the Supreme Court in appeals from High Court regarding civil matters. The appellate jurisdiction. Okay. 141. Consider the following statement and state which one is correct. Supreme Court of India has only original jurisdiction. No, it has other also like appellate jurisdiction, writ jurisdiction. It has only original and appellate. This one is also wrong. It has only advisory. Wrong. It has original, appellate, as well as advisory jurisdiction. Yes, D is correct with additional to jurisdiction also. Article 131 of the Constitution of India deals with the original jurisdiction of the Supreme Court. Article 132 to 136 deals with the appellate jurisdiction, and Article 143 deals with the advisory jurisdiction of the Supreme Court. Curative petition in India can be filed in Supreme Court under Article C 142. Okay, this much for today.